My background is in equality and discrimination, particularly disability. I've worked for a number of disability organisations. I was previously an advisor to the Disability Rights Commission, the statutory body dealing with particularly disability legislation. I've been involved in drafting the statutory codes of practice on disability legislation, the Disability Discrimination Act, also drafted disability-specific provisions of the Equality Act 2010, and I practice now primarily in discrimination with an expertise in disability legislation.
Thank you very much. And for the tribunal, Ms. Casserley's statement is at page 556 of the bundle, and the other documents in respect of her evidence are at items 38 and 39. Ms. Casserley, I want to first of all ask you about the main concerns that you have and you see in respect of women and disabled people, and then ask you to describe how those concerns have been affected by the pandemic.
Well, in relation to pre-COVID times, starting with the workplace, broadly speaking with disabled people, and including women, it's getting in and getting on. So there are significant barriers to disabled people getting into employment. Those are the recruitment stage, significant discrimination, both for those with what one would term visible disabilities and indeed invisible disabilities. Duty to make reasonable adjustments, which disabled people benefit from, not being widely understood, difficulties in its implementation, also the disability pay gap, considerable in any event, but particularly for women. Difficulties experienced by women more generally are amplified, as is generally the case for those with additional protected characteristics. According to the TUC, November 2020, the pay gap for disabled women is nearly 9 percentage points higher than the pay gap for women overall. Non-disabled men are paid 36% more than disabled women. Outside the workplace pre-COVID, access to transport, particularly when you're outside London. London has a very good accessible transport system, but as soon as you move outside London, that's much more difficult. Social care, particularly for those disabled people who are parenting, those experiencing domestic violence, accessibility of support for domestic violence. These are all areas where disabled women face particular difficulties. Since the pandemic, disabled people have been hit particularly hard by it. I don't think it's possible really to overestimate the effect of the pandemic on disabled people. Increased isolation, reduced social care, government policies. I heard the previous speaker talking about the fact that government hadn't taken women into account in the pandemic. They failed to take disability into account at all. At the outset, for example, the approach that was taken to disabled people in the rules and regulations regarding exercise. You can only exercise once a day. If you are someone with autism, you need to get out, and the government had failed to take that into account at all. So those regulations and the guidance around that had to be changed pretty early on. The guidance was altered, but it took that challenge before it was changed because disability hadn't been factored in. And that was a continued theme. So hospital guidance meant that people couldn't go in with an interpreter or with a carer. Again, that had to be challenged and changed. Disabled people were left out. And that was particularly difficult. In relation to get something as basic as getting food, supermarkets did not respond to the needs of disabled people. So, for example, if you had a non-visible disability, if you perhaps had autism, you felt overwhelmed by the physical space and you couldn't go to a supermarket to get your food, you were left off the list that was passed to supermarkets and you couldn't get shopping. There were people that that I had dealings with who hadn't been able to get a food delivery for weeks. And they had to get friends, if they could, to get those deliveries. So those are some very basic examples of how people were hit by the pandemic. And I think women bore the brunt of that, as they often do.
Thank you. We have the Equality Act making provision to, in terms of prohibited conduct, provision of reasonable adjustments. What do you see as the extent to which the Equality Act actually provides effective protection for disabled women? Where do you see difficulties and gaps in the Equality Act?
Well, overall, I would say that the Equality Act, it lays a very a good basic framework for discrimination law, and certainly compared to a lot of countries, we have a good basic framework. But there are some significant difficulties with it. The first and perhaps most obvious, I think, is that Section 14, which was intended to provide specifically for discrimination on the basis of combined protected characteristics, so for example, disabled women, was never implemented. And in fact, the government said that it was never going to implement it, and that's effectively dead in the water. So that's the most obvious gap. There are other difficulties with it. So it's reactive. Apart from the public sector duty and positive action, it relies on individuals to bring claims, and that's very difficult. It's difficult in the employment sphere because the provisions are complex. It requires an individual to have the energy to bring a claim. And if, for example, you're a disabled woman in employment, you need reasonable adjustments to enable you to do your job. The thought of having to go to an employment tribunal in order to get those rights is extremely difficult. If you're dealing with a non-employment situation, you have to go to the county court, you have to pay a fee, you have to go through a very difficult process, which is extremely user-friendly. So enforcement is a difficult issue. The positive action provisions, such as they are rarely used. In the context of disability, actually, it's much easier to use positive action in that a non-disabled person cannot bring a claim. So it would be extremely easy for an employer, for example, to reserve employment for disabled people. But generally speaking, they don't do it because they're frightened of the ramifications. So those provisions are rarely used, and they're not really understood. The potential for those has never really been realised. And the equal pay provisions are complex. Any proceedings taken under the equal pay provisions are extremely lengthy. They go on for months. They are, that's in terms of mass claims. Even on an individual basis, they're difficult for people to understand. And it would be a very brave person, I think, who brought an equal pay claim on their own, or indeed an indirect discrimination claim dealing with an equal pay issue. They're pretty forbidding. So I think those are the broad difficulties with it. Even with reasonable adjustment claims in the employment context, that is also reactive, and it depends on an employer knowing of the disability, knowing of the disadvantage. There's no anticipatory duty to make adjustments in the employment context. So, for example, if there's an inaccessible building, in the employment context, an employer doesn't have to do anything about that until they know that there's an individual disabled person that wants to apply for a job or that is employed. So really, I think that's not particularly useful in an employment context, unless you're talking about public authority and you rely on the equality duty.
Yeah, which is my next question. How effective have you, in your experience, do you think the public sector equality duty provided for under the Equality Act has been for disabled people, disabled persons, and specifically disabled women?
Well, the public sector equality duty has and had great potential. Its introduction after the Stephen Lawrence inquiry should have delivered real change, and in some circumstances, I think it has. It has led to the quashing of regulations which are unlawful and damaging. So, for example, youth offending regulations about restraining young people, they were quashed. Obviously, it played a part in the relatively recent case about facial recognition technology. But ultimately, it has been said in litigation to be a duty about process. If you look at the case of Bracking, which was about the closure of the Independent Living Fund, in the first case about Bracking in the Court of Appeal, there was some very good things said about the duty and what you needed to do in relation to the duty, and the decision to close the Independent Living Fund was quashed. But what the government did was it looked again at that decision, it reached the same decision, and the second time around, it was able to do that, and a challenge to that decision failed because it had gone through that process properly. So I think the difficulty is that once the process has been correctly followed, the decision as to how much weight is to be attached to those equality considerations is one for the decision maker. So ultimately, it's not really about action. And too often, equality for disabled women doesn't attract sufficient weight in that decision making, and that's the problem with the duty. It's not really about action. Ultimately, it is about process, and that core has never really played enough of a part in the duty, and it has. Particularly because the specific duties really were watered down so much, particularly in England. I know they are stronger in Scotland and in Wales. Then it doesn't really reach the potential that it should reach, and particularly because Section 14 isn't in place, you can't encourage in that sense, as perhaps you could if Section 14 was in place. You can't encourage those decision makers to consider discrimination in that context and to look at those particular issues that disabled women face. So it really does need to be strengthened and to live up to the potential that it should have, because public authorities should be leading the way.
Thank you. My final question, final point before I hand you over to the judges, and the key point, and that is in respect of implementing CEDAW. How do you think implementing CEDAW would make a difference?
Well, I think that my view about CEDAW is that it would enable more of a focus on women's equality. It would raise awareness of what more needs to be done. It would show that there is a willingness and an environment for change. It would strengthen the provisions that we have, and it will provide an interpretive tool for the provisions that we have. And what I also think is that it would enable there to be a systematic approach to all the areas of the Convention and to considering equality in all of those and how that might be achieved. Because at the moment there is a piecemeal approach to achieving equality and a reactive approach. And I think CEDAW would enable there to be a proactive approach to that.